Good afternoon, everyone. My name is Lisa White. I am CML's Membership Services Manager, and I want to welcome you for attending today's webinar on broadband and communications. Today's presentation is available on our website at cml.org under Training Materials, and the webinar is being recorded, and we will post that to our website under Training Materials probably sometime tomorrow if you want to access it or share a link with someone else who wasn't able to participate in the live version today. For those of you who aren't familiar with the webinar format, you should see a control panel to the top right of the screen. You have an orange arrow to the left of the panel, which will minimize the entire box. All participants will be muted for the webinar, but we encourage you to ask questions by typing them into the question box on the control panel at the end of the webinar. At this point, I'm going to turn it over to Mr. Sam Nameth, CML's Executive Director, who will introduce our presenter. Again, thank you so much for participating.
Lisa, thanks very much. Good afternoon, colleagues. It's a pleasure to have all of you join us for what I know will be an excellent webinar this afternoon. And I have the pleasure of introducing our presenter. I think many of you know Ken, but let me just say a few words about Ken Fellman. Ken is one of the nation's leading experts on telecommunications law and things related to that subject area from a municipal standpoint. He's a partner in the Denver law firm of Kissinger and Fellman, and for almost 35 years he's been involved with local governments not only throughout our state but across the country on issues involving technology, communications, broadband, public safety communications, and utility issues. He's provided legal services to a number of my colleague associations, the Association of Washington Cities, the Association of Idaho Cities, and of course our national organization, the National League of Cities. He currently serves on the Federal Communication Commission's Intergovernmental Advisory Committee. He's been an elected official because from 1999 to 2007, he was the mayor of Arvada. We've used Ken numerous times at the Capitol to testify as a witness on our behalf. He's done the same thing back in Washington. And currently, he's also the acting city attorney for the city of Littleton. He also plays a mean guitar. And he's got his BA from Johns Hopkins and his law degree from the University of Denver. I think you're in for a treat today. The topics that Ken is going to cover this afternoon are extremely important to municipalities at the moment, and it's a pleasure to welcome Ken Fellman to this webinar. Ken?
Thank you, Sam, and good afternoon, everyone. Let me start by formally thanking Sam and the great staff here at CML, Lisa and Lee, and Tammy when she was here to help set this thing up. I'm just going to give you the disclaimer at the start. We have more issues in this presentation than we really have time to discuss, and one of my goals was to put more substantive text in the slides than we're going to discuss in great detail, and hopefully then you can use it as a resource material, and you can certainly follow up with me offline to discuss it further. So away we go. 5 broad topics I want to cover here, and one of them, and it's a big one for a lot of us right now, are small cells, wireless facilities in the public rights-of-way, the impact of negotiated agreements, state legislation, and a pending proceeding at the FCC. We'll probably spend most of our time on this one because it has all those subparts. Quick update on broadband legislation, both at the state and federal level. A couple of issues about what's new in cable franchising. When Tammy was here, she asked me to put in something about streetlights. A lot of communities are interested in acquiring streetlights for a variety of reasons, and one of them ties into broadband applications related to smart cities. And then if we have enough time, we'll get into public safety communications and some issues going on there that will impact all of your jurisdictions. So that's the overview, and we'll move on from there. So most places have heard of mobility, and mobility is a wireless infrastructure company. And while they may be the hot issue in a lot of communities today, let me suggest that we ought to talk about the issue of small cells in the rights of way on a much broader scale. A number of your communities have heard from Verizon. There are also communities that have heard from Zayo, Crown Castle. And if you haven't heard from any of these companies yet, they're coming. So where I start when I look at these companies and this issue is our local codes, zoning codes. All of you have, or should have, I guess, provisions in your land use code today that deal with what we have generally called cell towers and placement and how they get approved, what the applications require. And I would suggest that you need to look at your codes and determine, do they currently address facilities in the rights of way, not just towers on private property? If they do they address facilities in the rights of way the same way that you address issues on private property with either conditional use hearing or special use hearing requirements, other public hearings? And I'm going to suggest that that may not be the best way to do it. And also an important need is to check your rights of way and your streets provisions of your public works codes and your regulations. And I would say that in my experience, usually most communities find that some kind of upgrade and amendments are necessary. So the companies that want to put these vertical assets in your right of way have an unrestricted right to do so. No, they don't. They don't under federal law. The key term there being unrestricted. They don't under state law. But they do have some rights. And in a few minutes, I'm going to be talking about House Bill 1193, which passed out of the Senate Local Government Committee the other day. And assuming that it breezes through the Senate, will probably be signed by the governor and go into effect at the beginning of January. So more on that in a few minutes. So you have a company that has access to the rights of way under state law. Do we have local police power controls? I would suggest that we do. Can you impose limits, height limits in the rights of way? I think you need to ask, do the height limitations that you have in each of your zoning districts apply on public as well as private property? And the answer to that is yes. Do you have the kind of definitions that extends that coverage of public property into the right of way? I've seen a number of communities that clearly say that the zoning district boundaries extend to the center line of the rights of way, and I think that's the way it should be. So if you have that kind of control and you do have height limitation requirements, you can avoid what we're seeing now in a number of places where companies are coming in and asking to put 80 to 120 foot poles in the rights of way. Other authority, I don't know why this was coming in one line at a time. I thought I had set it up so that it would just auto-populate, but I'll just play through it. So local, do you have local authority that you can where you can limit the number of the poles, both for public safety reasons or for aesthetic reasons? I think that you do, and I think most communities have code provisions or certainly have the police power authority to amend your codes so that you can avoid the ugly monstrosity that you see in this photograph. But again, we're going to have to keep an eye on the the new state legislation. I think we're pretty well covered there, but we'll get more into that in a minute. Bottom line, make sure your code and your administrative regs address the full range of police powers that you do have. And we'll talk about federal law a little bit later, but there's an overriding provision in federal law that says your local requirements cannot prohibit or have the effect of prohibiting the provision of service. I doubt whatever company put up this poll would have been able to prove that if they didn't do it this way, that they would not have been able to provide service. But that is sort of the fail-safe that the industry has with federal law. So One of the things that local governments are doing is negotiating rights-of-way license agreements with some of these companies that want to site facilities in the rights-of-way. It doesn't have to be this way, but a format that I have been working with and that a number of my municipal clients are comfortable with is both a master agreement covering the main terms. I mean, the kinds of things you would think would be in a master agreement: definitions, the grant of authority, the term, preference for installations. We want these things to go on existing vertical infrastructure before we put up a new pole. Compliance with local law, insurance indemnification, issues that would be common to any kind of site plan review regardless of the location, relocation issues, interference issues, emergency contacts, the kind of stuff that you'd expect in a variety of different kinds of rights-of-way agreements. And then those same agreements would have individual site licenses so that for each individual site that a company would want to attach to or place a new pole, there would be requirements for site plan, the review of that site plan, again, compliance with local code provisions, design criteria would be put into those as well. So once we have the first company that starts installing these things in your rights-of-way, then we start getting impacted by the non-discrimination provisions of federal law, and I think we can actually find those similar provisions in state law that require companies to be treated, or folks putting stuff in the rights-of-way to be treated on a comparable basis. Some of these companies are service providers, the Verizons, the AT&Ts, the T-Mobiles of the world. Some of them are just infrastructure owners, and they build the facilities and then they lease space to the providers. Mobility is that kind of company. They say they're not a service provider, they're an infrastructure owner. I've had this question come up a couple of times. If we let a company like Mobility come into the rights-of-way, can we tell all the other service providers, you must put your stuff on their pole? We won't let you put up a different pole. You can't do that. That would be contrary to federal law, probably contrary to state law, and would probably cause you to end up in a lawsuit. The ultimate goal, I think, from a planning standpoint, and I start from the premise that most of our elected officials today, which is different than 15 years ago, actually understand how important broadband is in the communities, and these small cells will help improve those networks. So we want to facilitate this, but we want to do it in a way that works in conjunction with all the other issues that our municipalities are dealing with, and certainly avoids the tower clutter that you might otherwise get. One of the questions that's come up a couple of times for me, because Mobility is not a service provider, they're an infrastructure owner like Crown Castle or American Tower Company. I've had a number of questions say, our state law, CRS 35, 5.5, 101, grants the right into the rights-of-way to providers of service. So could we say no to Mobility? They think they have rights under that statute. I think you probably can make an argument that, yeah, you could say no to them because of that. Even under 1193, the new statute we're going to talk about in a minute, doesn't change that. The statute applies to service providers. But if you do, right, you can't say no to Verizon. You can't say no to AT&T. They come under the statute. I think most of us who have been jaded over the years by the legislative process here, if a couple of communities start saying no to infrastructure companies, we can pretty much bet that next session there will be an amendment to the law that changes that. And as you'll see in a minute, federal law doesn't have that distinction. It applies to the infrastructure itself. So let's talk about federal law for a minute. I'm not going to read each of these statutory provisions. This is part of the takeaway for you, but I've tried to highlight the different parts of the federal law that apply. From the Telecom Act of 1996, we've got two sections, 332 and 253. 332 basically has no unreasonable discrimination requirements, To me, that means you may discriminate if you have a reasonable basis for it, but basically you cannot unreasonably discriminate among providers of functionally equivalent services. So one question that came up, well, what if you allowed somebody to come into the right-of-way but you had camouflage requirements? And now you have a new company that comes in and you let them put a standalone tower. Are you subject to a charge of unreasonable discrimination? I don't know the answer to that question. It's an interesting one, and it may come up. And frankly, even if it would be a violation, I don't know what a good remedy would be. But the bottom line is keep the unreasonable discrimination issue in the back of your mind as you're going through this. Also in 332, the big win that local governments got in Congress in 1996 on this issue was, for the most part, local land use authority over the siting of these facilities is preserved. That's what paragraph A says. There are a handful of exceptions to that. So, and that's starting in section B. So we already talked about can't discriminate among providers of functionally equivalent services. You cannot prohibit or have the effect of prohibiting the provision of wireless service. I had an elected official ask me not too long ago, can we just say no anywhere in residential districts? I would be nervous about that. You can limit it, you can try to get it in other districts, but I think you have to have a provision that if that's the only place it can go, then it's going to be permissible under certain conditions. Also, the exceptions is local governments must act within a reasonable period of time. Congress didn't tell us what a reasonable period of time was, so the FCC has established some rules and some shot clocks, which we'll talk about a few slides from here, I think in the next slide. Any decision that you make to deny must be in writing and supported by substantial evidence contained in a written record. That seems sort of clear and logical, but there have been federal court cases all over the country. It means what kind of writing? And I'm oversimplifying here, but you can't take the application and stamp no on it or denied. That's not good enough. But you don't have to have a full-blown findings of fact, conclusions of law. Something in writing that references the evidence upon which the decision is made is usually good. And I would suggest, even though it's not in the statute, whatever you decide is going to be your policy for when you deny these, do it when you approve them as well. You cannot regulate, most of you know this, on the basis of the environmental effects of radio frequency emissions. That's what freaks everybody out in the community. These things are going to fry our brains. They're too close to the school. They're too close to the park. The FCC adopts the standards for radio frequency emissions. What you can do is require in the application that the company demonstrate through a report from their radio frequency engineer that they're going to be consistent with federal emission standards, and you can test it from time to time. So compliance with the federal law can be a requirement of a local approval. And of course, any applicant that feels like their rights have been violated under the statute can file an action in court to try to take action to the contrary. So for the federal law shot clock issues, right, what's a reasonable time in which to act? The FCC said a number of years ago that, and this relates, as I said before, to facilities. It's not just for services provider, but for anyone that's applying to put up facilities. If they are applying for a new facility, so a new tower, and actually under this shot clock, a new pole in the rights of way, even if it's a 30-foot pole, 150 days to act. If it's a co-location, and the caveat is co-locations that are not mandatory co-locations under a subsequent federal law, which has become known as Section 6409 of the Spectrum Act. We'll talk about that in a few minutes. You have 90 days to act on a co-location. So whether or not they're a service provider, 90 days, 150 days, and the remedy, if you don't act in that time period, is that it simply creates a presumption that you have not acted in a reasonable period of time, and the court can say to the city, you must act. It does not result in a deemed granted remedy. That's very important because the rules for Section 6409 co-locations are different. So let me move then to Section 253 of the Telecom Act, and that deals with rights-of-way regulations, and it is titled Barriers of Entry. So your rights-of-way regulations generally, and this was written at a time when we were only talking about wires because the wireless technology had not developed to the point it has today, but it applies today to wireless facilities as well. So you can't prohibit or have the effect of prohibiting the ability of any of these entities to be able to provide service. Section C gives local governments the ability to both manage the public rights of way, so there's our police powers being preserved, and to require fair and reasonable compensation from providers to use the rights of way. Now, don't get excited about that because that's the federal law, and for us in Colorado and in many other states, it has been preempted by state law. That was Senate Bill 10, also passed in 1996 and upheld to our collective chagrin by the Colorado Supreme Court as an appropriate preemption of home rule authority. So we are not allowed to charge for the use of rights of way with the exception of cable television service. But if you do have a local law that an industry entity believes is a violation of Section 253, they can apply to the FCC or to a court seeking preemption of that law. So moving on to the co-location rules from Section 6409. All right, some of you may remember the Middle Class Tax Relief and Job Creation Act of 2012, which was one of those acts where Congress had waited till the 11th hour and all these tax credits were going to disappear, and at 5 minutes to midnight they passed this bill. It's a big bill. It's about 100 pages. Less than half of it has or relates to tax relief and job creation. The majority of the bill, a little bit more than half, has come to be known as the Spectrum Act. It covers a wide variety of radio frequency spectrum issues, mostly related to public safety communications, except for the fact that there's one small paragraph, Section 6409, which mandates that when an applicant wants to co-locate on a facility and it does not substantially change the physical dimensions of that facility, and they use terms of a tower or a base station, the local government may not deny and shall approve, that's the congressional language, that co-location request. Now, they didn't define what a tower was. They didn't define what a base station was. They did not define what an eligible facilities request was. They didn't define, most importantly, what a substantial change to physical dimensions would be. So the FCC has stepped in as the expert agency to tell us what Congress meant. And just as a side note, I was speaking a couple of years ago to the top staffer for the Republican leadership in the Senate Commerce Committee, and he told me this section was introduced as a Christmas gift to the wireless industry. And I'm sometimes surprised, even today, there are a number of jurisdictions out there, and if yours is one of them, you need to get working on this, that have not updated their codes to deal with these mandatory co-location rules that the FCC has provided us. Now, this one slide is a 60,000-foot overview of the FCC rules, and I have done 90-minute presentations just on these rules. So that will be the topic for further discussion at some other time. But basically what the FCC did was they defined all these terms that I've got on the left side of the slide. And if you have an eligible facilities request and it does not amount to a substantial change in the physical dimension, it's got to be approved within 60 days. And if it is not approved within 60 days, the application is deemed granted. And it's 60 days from a complete application. So it's critically important that you have these provisions in your code, that you have the requirements for what you need from an application, so that you have all the information at your at the counter that will give your permit people the ability to determine, is this a substantial change, in which case they have to go through the regular zoning process, or is it not a substantial change, in which case we have to approve them within 60 days. So I would commend to you National League of Cities and a number of other local government associations, NATOA and NACO, got together with two of the wireless industry associations and came up with a model ordinance where they all agreed, the industry and our national associations, what these terms meant. And if you have that kind of language in your code, everyone agreed it wouldn't violate federal law. Some of your communities are members of the Colorado Communications and Utility Alliance, the CCUA, which is actually an affiliate of CML. And CCUA then took that model national ordinance and made it Colorado specific. So if you are CCUA members, you have access to that as well. Okay, House Bill 1193. So this is going on all over the country. There's at least 30 states that have either passed laws or have laws pending where the wireless industry is trying to streamline the process and in many cases preempt local authority when they want to site facilities that they call small cell facilities in local rights of way. I will tell you that CML and CCUA and CCI were in negotiations with the wireless industry from September on and with the sponsors of the bill. And while we're going to get a bill, and it was obvious we were going to get some kind of a bill, they had Democrat and Republican sponsors in each house. The Colorado bill is nowhere near as bad as the bills that we're seeing in other states. And the goal was to get all the bad stuff, the really bad stuff, out of the bill. And while it's offensive to all of us for the state to tell us how to run our municipalities, we tried to get this bill to a point where it at least mandated stuff that most of us are already doing and that we could live with. And I think we've gotten there, and I know that CML felt and CCUA felt that we could at least take a neutral position on the bill because as much as we don't like the mandate, we can live with the result. And if you'd like to talk further about what some of the other states are dealing with, I'm happy to share some of that with you and some of the really bad stuff that we got out of this bill. But the key things to remember, this bill says, and I know this freaks out planners and some land use attorneys, the industry will now have a use by right to place small cell facilities in the rights of way in any zoning district. But that's all that is a use by right. It's subject to all requirements of your zoning district. It ties back to my initial point about reviewing your codes. And if you've got a 30-foot height limitation in an R1 district and they want to build a 40-foot pole, the answer is no, because they may have a use by right, but it's subject to the requirements of that zoning district, as long as your code says that that applies to rights of way. It allows these companies to make batch applications. So if they have 5 sites, they can submit them all in one application. One of the concerns I've heard is, what if they come in and they've got 90 sites? How are we going to get that done in the new time period? Because the other thing this bill does, you see on the bottom of the slide, it shortens the 150-day shot clock under federal law to 90 days. Well, in most cases, I think most of our communities would be able to get this done fairly quickly. I can't imagine a company applying for that huge a number of sites, except in the largest cities, which usually have more robust staff capabilities. And frankly, this shot clock is just like the other federal shot clock requirements, is that there's no deemed granted remedy. The failure to act in the shot clock period simply means there's a presumption that you haven't acted in a reasonable period of time. And I think if a company was stupid enough to take a city to court because they didn't act within 90 days and the city came back and said, look, we normally would get this done in 90 days, but the week before they applied, Walmart applied and Excel applied for a new substation, and we have 2 planners. I think you can rebut the reasonableness presumption if you have the right facts. As far as fees go, remember, we're already limited in what we can charge under Senate Bill 10 for any charges for attachments to city-owned poles or town-owned poles. It says we're limited to what the federal pole attachment law says we can charge. Now, under the federal pole attachment law right now, they have no regulations on what wireless attachments can be. they do regulate it. You have poles owned by CenturyLink, owned by Comcast, owned by XL, owned by co-ops, and the pole attachment rules at the federal level deal with how much those companies can charge each other for putting their wires on one of the other company's poles. And it's pretty small. It's like 14 or 15 bucks a pole per year. I would expect the federal government to come up with wireless rules. It's going to be a small number. Do not look at this, if you own a lot of poles in the rights of way, as a revenue generator. There was an exemption that cable wanted at the last minute for Wi-Fi equipment. Companies like Comcast and Charter put Wi-Fi nodes on their wires, so not on the poles, but on the wires between the two poles. And the language they proposed would have exempted them from any kind of permitting requirement. What we found when Kevin Baumer from CML and I looked into this further, a number of municipalities haven't been requiring permits for this, in part because sometimes they didn't know. The cable companies are just putting this up. Some communities do have specific requirements in their code, and language you can point to, I think, in the National Electric Safety Code and maybe the International Building Code that would require permits. So we were able to modify that exemption in the Senate earlier this week to basically say if a municipality requires a permit, they don't have to, but they may continue to require a permit for that kind of attachment. So that was kind of a last-minute change. Now, moving to the FCC, because it just wouldn't be fun if we were only being attacked at the state level. There is a proceeding pending right now that where the FCC is looking at basically all things wireless. How is wireless siting going? How effective is it? Are local practices doing anything to impede the deployment of wireless broadband facilities? I mean, they've teed up some of these issues by asking questions in a way that it's just begging for the industry to come back and say, oh, sure they are, and here's all the examples of the bad actors. So that's pending now at the FCC. We have had comments that were filed on March 8th, and there's been a lot of comments filed, both by the industry and local governments all over the country. CML filed comments together with a number of other jurisdictions, and it's been interesting reading these arguments. I do think that the FCC is going to come out with some kind of preemptory rules at some point, and I know that one of the goals, given that if they do that it will likely be challenged in court, is going to demonstrate that they acted in an arbitrary and capricious manner given the record. But some of the arguments local governments made is they don't have authority under Section 253 to limit our police power or our charges. One of the questions that was asked, and it doesn't affect us in Colorado, was should we limit what reasonable compensation is to cost recovery only? A lot of states where they can actually charge more than cost recovery have advocated, no, you can't do that. Again, lack of authority under 332, we talked about how that preserved local authority, and then 10th Amendment issues about the feds interfering with the use of local property. There were numerous examples of local governments who are doing it right now, and the industry causing problems. And we don't need help from Washington on this issue. And then one of the problems, and this always bothers me, but it happens all the time at the FCC, the industry always argues without naming specific local governments. Now, some of the comments they filed did call out jurisdictions individually, but many of them were like a city in Iowa did this and a county in Maine did that. And you know, those of us who have done stuff in court know that that kind of stuff wouldn't even get admitted into evidence. But the FCC is a lot more loose in how they allow this stuff, and they often make federal policy based upon anecdotal examples like this of communities that don't even have an opportunity to defend themselves. So I think we may get some kind of order from the FCC, but it's interesting that in the past, while they haven't been shy about preempting local government. They've been a little bit more restrained about preempting state government. So the fact that House Bill 1193 is passing, they may come out with a rule that says if you're in a state where the state hasn't acted, these are the rules. And it may be that we actually end up in better position because of this state law that most of us don't like than we would be if we didn't have any state law. So keep an eye on the FCC, and CML and I will keep you advised on what's going on there. I actually have a meeting there tomorrow, and this is one of the items that is going to be discussed. So bottom line here, look at your code, amend it if you need it. If you don't have criteria under which you allow, when you allow polls in the rights of way, you should, at the bottom of the slide, some of these, these are some of the things you'll hear when these companies come to talk to you, make them back it up, get a copy of their agreements. And then I want to let you know that some of the people in these companies, they're nice people. Some of them have been more responsive than others, but most of them have been responsive. But their leadership, in some cases, has not been as equally respectful as some of the people in the field. So I just thought I would end this topic by giving you a quote that the CEO of Mobility made in this month's edition of AGL magazine. He actually said this. This is a quote from the magazine, and I've now said to, and this is a company that when they first started, they're better now, but when they first started, they got nailed in Prince George's County. I don't recall if it was Virginia or Maryland. They both have a Prince George's County. They deployed a bunch of stuff first and asked questions later, filled out begged forgiveness and filled out the application later. They got fined by the city of Baltimore by putting up poles in handicapped access ramps. And this is what their CEO thinks of many of our communities. And maybe when you're contacted by Mobility, you might ask them, are we one of the communities that your CEO thinks are stupid and don't care about what goes on in their community? So something to think about. Okay, broadband quickly. We had Senate Bill 42 earlier this year. It would have repealed Senate Bill 152, which is, as you all know, is the bill that we have to go to a vote if we want to do municipal broadband. It was killed, party line vote, 4-3. Thank Senator Guzman, if you see her, for sponsoring this, and Senator Donovan for co-sponsoring. And you can look up the Republicans on the Business and Labor Committee who killed it. There's been talk of easement perfection. This is companies like Tri-State on the West Slope, when they have easements and they've got a bunch of fiber, and they can lease out some of that fiber for municipal broadband projects. But the easements that they got initially say they have an easement to use this property for anything related to their own operations, their electric operations. So those easements have to get perfected. I don't think we're going to see a bill this year, although there was talk of one that would make it easier to perfect those easements, because right now one property owner can hold up the ability to facilitate more municipal broadband. There's no federal legislation yet that I can give you specifics on, but there's been a whole bunch of talk of rewriting the Telecom Act now that there's one party that controls both houses and the White House. So I do think we're going to see federal legislation, and I expect it will be preemptory. So we're going to have to keep an eye on it. The FCC we already talked about. The wireless proceeding, they're also doing things now like rolling back consumer privacy rules, rolling back the net neutrality rules. None of those directly affect municipal operations, but they're consumer issues that we care about. Oh, on the easement perfection issue, I do know that in Southwest Colorado, they've been talking to Senator Bennett about that. So there may potentially be some action in Congress on that issue. Cable franchising. So it may not be going away soon, but someday cable franchising is going away. We all get our, or not all of us, but many people are cutting the cord. They're getting their video, what's called over the top, which basically means you have your internet subscription from someone and you're getting your video content from someone else. And I think that's the way the industry is moving, and I don't know if it'll happen in 5 years or 10 years, but I don't see an alternative revenue stream on the horizon. So get ready at some point to have our local governments acting or operating without the franchise fee revenue we're getting, without the PEG support and the PEG channels that we're getting. You know, we have had minimal competition for true cable. CenturyLink has acquired some franchises, but now they're stepping back and they're not expanding the way they initially said they were going to. And the other new thing in cable is that traditionally a lot of cities have iNet agreements with cable where they get fiber connectivity for their own city operations at very reasonable prices. We're seeing 400, 500% increases as the current iNet agreement ends, and cable companies saying this is now a commercial transaction. You can negotiate your connectivity with our business offices. So if you are in franchise negotiations and you do have problems, there's a way to address them under the formal franchise renewal of federal law, but it's expensive and it's time consuming. If you do follow that process, you usually get a little bit more than you were going to get. I wanted just to highlight there's a new company called Layer 3 out there. They appear to be providing traditional cable packages. They're just starting to talk about services in Colorado, and they just did a deal with Longmont with their municipal broadband network, but they're talking about coming to Denver and some other places. They look in a lot of ways like a cable company, but they claim that they're not a cable company. And in some of their federal filings, they appear to say that they are in this category that makes them look like a cable company. So do they need a franchise? I don't know, but it's something. I just met with someone this morning from one of our municipalities for over an hour talking about how do we get more information about this company if they really do want to start deploying all across Colorado. And they may not be a cable company, but I think if they approach you, we need to ask a lot of questions about that. So moving on to a different topic, streetlights and smart cities. I'm not going to talk about the specifics of this slide other than to say you can click on these links and get a lot of interesting information about what smart cities are, why it's important to have the kind of networks that will allow us to do smart cities. The White House link is an initiative that the last administration came up with to create this smart cities initiative. And it's unknown at this point what the current administration is going to do with that. So we don't know what kind of help we're going to be getting from the feds on this. But we need better broadband if we're going to do smart cities. You've heard the term the Internet of Things. Remember this, 3 critical components if you want to be a smart city. You've got to have sensors all over your city to collect data. And that means you have to have connectivity, so you have to have good, robust broadband networks. And then you have to have smart people who have the capability to analyze that data and to do things with it that will help us provide better services to our citizens. So this next slide just shows some examples of some smart local government apps. The labellium.com website that I've cited there is a good source of information for others. I'll just give you a quick example. I was talking to the former CEO or CIO rather of the city and county of San Francisco when he was still there. They were doing smart city parking apps where you can put an app on your phone and you're driving around San Francisco and you could see where there was an open parking space. How cool would that be in some places? Well, somebody decided they do their own trash pickup from the city. And a lot of times they have very narrow streets and their trash trucks would sit behind trucks that were double parked, pumping emissions into the air, waiting to go on. They said, what if we take this parking stuff that we're using for parking spaces, and we started looking at the routes of our trash trucks and then sending our trash truck drivers information, don't go down that street now, but divert this way. And they found that they were getting done with their routes 15% less time. They were putting 20% less carbon emissions into the atmosphere, and they were saving about 20% on gas. So that's an example, a real-life example of smart cities. So cities are looking at buying streetlights, and some of them think, I believe all of these, there can be extensive cost savings. If you own your streetlights, certainly you have more flexibility in the kind of light fixtures you can use, and from our purposes today, it gives you more control over attaching those kind of sensors to your streetlights to be able to do smart city applications. Those of you who have worked closely with Excel probably will agree with me and say it's going to be a long time before Excel starts allowing those kind of attachments I don't know, some of the co-ops around the state are more open to that, some may not be. But there's a reason to buy your streetlights. Now, if you are interested in buying them, or even if you're not, but you're growing in certain areas, a lot of our codes say the developer pays for the streetlights and then deeds them over to the utility. Why doesn't it say deed it over to the city? You just pay for the energy that way. You don't pay for the maintenance. You do your own maintenance. You're probably going to hire the same subcontractor that Xcel hires, and you get it done cheaper. If you do want to negotiate and you're an Xcel community, do a GIS study, pay for it, know exactly where every one of your streetlights is. I guarantee you Xcel does not know. And if they don't know and you want to buy the streetlights, they will do the GIS study and bill you for it. So first step, and then get an appraisal, get your value, and then move forward from there. If you are going to buy the streetlights, Xcel will require you to sign a non-disclosure agreement. All of us who are city attorneys will say, how could we ever do that? If we want to buy the streetlights, that's going to be done in a public meeting. So they'll agree in an NDA, and not only will it ultimately be approved by council in a public meeting, but the PUC has to approve it too. So it's a sort of, some things are not disclosed, but at some point they are. So the bullet points here kind of highlight what you will need in a non-disclosure agreement. And remember that most of your franchises give them you have to provide a 1-year notice. So you're going to need to get your counsel on board if you want to provide that notice and authorize at least the ability to begin condemnation if the negotiations do not go well. And then lastly, very quickly, Public Safety Communications, FirstNet is the name of the entity that was created in that Spectrum Act, and their job is to build a nationwide interoperable public safety communication network. It's a great thing if they do it right. Congress only allocated about half the amount of money that it's going to take to get that network built. So they need a private sector partner who will use that spectrum for commercial uses, or some of it for commercial uses, but also agree to build out the rest of the network. AT&T appears to be the contractor they want to work with. The award of the bid was challenged just this week. I think it was dismissed by the Court of Claims, so I think FirstNet is going to move forward with their contractor now. What they're going to do is they're going to create a state plan in every state. They're going to deliver it to the governor. The governor has 90 days to decide we're going to opt into that plan or we're going to opt out. If they want to opt out, then the state has to come up with basically a better plan. It has to show that it's interoperable with the federal network. The FCC has a proceeding pending right now to determine what the criteria is going to be to determine, is your state plan technically sufficient and interoperable with the federal network. FirstNet has already made it very clear that they do not want people to opt out. The statute says you can opt in or opt out, either one. But FirstNet does not want states opting out, and it looks like they're going to try to make it very difficult. The problem is they may provide a network to the governor that only covers part of the state. And frankly, the folks I'm talking to at the state here and a number of our public safety providers on the local level are concerned that we're going to get a network through FirstNet that covers I-70, I-25, and a couple of ski towns. And we've tried to explain to FirstNet in some of the meetings we've had with them that floods and tornadoes don't occur in the highway corridors all the time. Fires too. And it may be that the state can do a better job. So we will see what happens, but I would encourage you to talk to your public safety people in your either local or regional public safety authorities, and they're hopefully on top of this, but it's something to look at. So with that, I guess we will go to questions. And Lee is going to help me see if we have any questions.
And while Lee and Ken are looking at that, I just want to remind you of a couple of quick things. The annual conference coming up in Breckenridge, June 20th through 23rd, registration is open. Your CLEs for participating, we did receive 2 general credits. To report your CLEs credits by participating in this webinar, we did send the instructions via the last reminder email, but go to cletrack.com, click on CLE transcripts, log in, and select Enter Online Affidavits. Our course ID number 757435. 757435.
Okay, so we had set this up that we're going to go till 1:30, and I really wanted to leave a long time for questions. So please don't be shy. So the first question that we have was, what's the third thing for smart cities? I said sensors and smart people to analyze data. So the third thing was connectivity, good, robust broadband networks. If we don't have that, then the sensors aren't going to work. The next question is, if a municipality owns all of the poles in our rights-of-way, can we require cell facilities to attach to your poles rather than placing on their own? And the alternative, can we require placement of the new poles, or can we require that the placement of a new pole belongs to the city? The answer to that question is yes. And what I have tried to do in some of the both the codes and the license agreements that I've worked on is to create a priority that the municipality wants. So in some it says, especially in communities that don't own their own light poles, use our traffic signals. Now some public works folks don't like that. I have not been able to find anyone who can demonstrate to me that these facilities will interfere with a light pole, but so I think you can protect the usage. But again, set up a priority. Use the light pole. If you can't use that, use a traffic signal. If you can't use that, use a light pole. And if that doesn't work, then and only then will we consider allowing the use of a standalone pole, and then subject to certain kinds of aesthetic criteria. A couple of other things on that point. In communities where you do have a private investor-owned utility that won't allow attachments to streetlights, and right now Xcel's policy is we do not allow attachments to streetlights. They've said they're reconsidering that policy. I hope that they do that and do the right thing and make their poles available, but as of this point they haven't. So I've had a couple of municipal clients say, if you can't go on a traffic signal, our second choice is we'll let you pay to take down that light pole that Xcel Energy owns, and then we will let you pay to buy us a new pole that looks just like it, and now the city will own that pole, and we'll pay Xcel for the energy that the streetlight uses, and we'll let you put your wireless facilities on top of that pole, run the wires down the inside of the pole, put your radio antennas, which are part of a small cell facility, inside the pole so it's not visually obtrusive, and do that. So yes, you can require those kinds of things. Let's see, next question was, does the information presented with respect to facilities located in the rights-of-way also apply to town-owned property / facilities, e.g. towers or poles? That is one of the important, really bad things that we got out of House Bill 1193. In an earlier draft of it, it was not limited to rights-of-way. It was also covering municipally owned property outside of the rights-of-way. And again, in some of the states that have passed these laws, those kinds of terms appear in those statutes. We were able to get that out of the bill, and frankly, we had a sponsor who insisted it was not going to be in the bill. So thank Representative Tracy Kraft-Tharp if you talk to her for that, and a couple of other bad things that she said are not going in the bill. And that what House Bill 1193 covers is simply facilities in the rights-of-way, and it does not apply in any respect on any town or city-owned property or facilities outside of the rights-of-way. Okay, what do I think are the boundaries of the police power that 1193 preserve? I mentioned height. What about co-location requirements, screening, denial based on aesthetics? Good question. So height is one. Another one that wasn't mentioned in the question, but I think is critically important, is separation distances. So if you do decide to let a company put up a standalone pole, and I know when Edgewater was amending their code, we talked about that issue, and it being mostly a residential community, and like probably every community, we'd like to avoid pole clutter. The issue was, well, what if one company comes in today and they can actually demonstrate a good reason to put up a standalone pole, and then another company comes in next week and they can also demonstrate that reason. Do we have two poles that are 20 feet away from each other? I think for aesthetic reasons, they decided, and I think it is within the scope of their police powers, to put separation distance of 600 feet. Why 600 feet? Because somebody in Public Works said that's about the size of a city block. So if Verizon comes in and they want to put up a pole on a block where mobility also already has a pole, the city can say, you know what, you can't go on this block. You can go on this next one, on this side or that side or around the corner, but we can say no here. And vice versa for the company. If Verizon has the pole and mobility wants to come in. Excuse me. So I think we can have separation distances. Some of the more aesthetic criteria that we've tried to write into some of the license agreements, and admittedly, it provides discretion on the community or with the community development director or his or her designee. But we have language related to view corridors, painting of a color that the city would require, not having ground-mounted equipment. A lot of the equipment can either be put on or inside of the pole. So for an aesthetic reason, you might want it inside so you don't have like three things hanging up and down the pole. The wires can go in the pole. Some of these facilities, they might want to put ground equipment, and there's technology now that allows that to be buried and still with easy access to for maintenance. So if you don't want a little green box at the base of the pole, you can require that. So I think the police power is pretty broad when it comes to most of these issues, and in particular when it comes to aesthetics, though. I think we all know that we get into a gray area as to what's reasonable and what's not reasonable, and most of us can pretty much tell if it passed the smell test or it doesn't pass the smell test. And if you can avoid the extremes, you can probably avoid being the test case on the scope of police power. So I hope that was responsive to your question, Jeff. Okay, next, can a municipality require undergrounding of all appurtenant or accessory telecommunications facilities? So I think I addressed that in the last question, and yes. Now, if maybe there's a unique situation where it would be unbelievably costly to do so. I mean, you could probably come up with some fact situation where somebody might be able to demonstrate a need to put something above ground. But the other thing is, remember, on these small cells, I didn't say this earlier, they're called small cells not because of their physical size. Small cells refers to the geographic coverage of these facilities. They can be smaller. The antennas can be smaller than a cell tower antenna, but not necessarily. I've seen some of them that are basically the size of a panel antenna that you would see on a traditional cell tower. And every small cell facility has at least 4 components: the antenna, 2 radios, and a power meter. Denver has done a pretty creative thing with Verizon Wireless. I saw some pictures of some parts of Denver. I think it's adjacent to the Union Station neighborhood. So you've got historic buildings. You don't want these things to be ugly. Verizon Wireless had some poles that were relatively low in height, but XL said no as far as co-locating. So they have these nice poles that kind of have a wider base, and they're painted the same color as the other poles. You can't see the antenna on top, and all of the equipment is inside of, it's not underground, but it's inside of the base at the bottom of the pole, and you don't know it's there unless you really know that it's there. So I think you can require that. All right. Let's see. Scroll back up to this one. How is it not a taking to require a permanent physical invasion of city property? Well, Quest v. Denver, Colorado Supreme Court, 2001, I believe. That was one of the arguments that the city and county of Denver made in that case, and we are stuck with a decision that all local governments are creatures of the state, and if it's a matter of statewide concern, the state can tell us what to do. Now, it would be a taking if the federal government imposed that. I strongly believe that without a state restriction, the federal government has no authority to tell a local government what it must and must not allow on a particular property. Like I don't think they could say you must allow attachments to every one of your light poles. But I think based on the Denver v. Quest case, and I would love for somebody to disagree with me on that and show me what the analysis would be, but not having read the decision recently, because it gives me a stomachache every time I read it, I would say that that case stands for the proposition that the state can mandate this of us. What resources would I recommend for developing a telecom-specific permit process? So I mentioned the CCUA group before. Excuse me while I take a drink of water. And they do have some model agreements that that deal with both code provisions and rights-of-way agreements. They haven't been updated in a couple of years, or well, the ordinance provisions in a couple of years and the master license agreement in about a year. There are a number of communities right now that are working on this. I mentioned Edgewater amending its code recently. Arvada amended its code. Centennial has some really good administrative regulations. There are others. Aurora is negotiating now with both Mobility and Verizon Wireless. And one of the things I know that Aurora has said it would do when it gets done with those negotiations for the CCUA is to allow the CCUA to take the Aurora agreements and make them generic and sort of turn them into model agreements that can be made available to others. So, you know, I think it's important to start looking at your code and start looking at your rights-of-way agreements and how you might do it. And I'm certainly happy to talk to anybody offline about when some of these other agreements are going to be available on a more generic basis to you so that you don't have to reinvent the wheel. All right, next question. Any examples of worst case stacking effects of the FCC's rules implementing 6409, allowing for 10% and 20% increases? No, and here's why, Linda. One of the issues that the FCC had to decide when they were adopting those rules was if they're going to agree to a 10% increase for facilities in the rights of way, 10% or 20 feet, or I think it's 20% or 20 feet for facilities that are not in the rights of way. Is that from the current height? So that, you know, I mean, that's ludicrous, right? A 40-foot pole today could be a 120-foot pole a few years from now if you keep allowing 20-foot increases. That was one of the issues that local government won on in that rulemaking, and the final rule said the percentage increase and the total foot increase is from the initially approved site. So once you increase the height by that much, you are done, and you don't get to keep increasing it. All right, next question. We're reviewing a license agreement from Verizon. Are there particular terms you suggest we be on the lookout for and try to negotiate changes to or make sure to add? So I'm guessing that you have the master license agreement that Verizon presented. I've been in multiple meetings with them in multiple jurisdictions where they have said This agreement was actually drafted by a city attorney in Arizona. And as I looked at it, there's a lot of it that's pretty good, but it was from a city that owned all of its own light poles. So for many cities in Colorado, it doesn't work without modifications. This particular question, I note, is from Fort Collins, so you do own your light poles. I would say, Ingrid, there's nothing that's coming to mind right off the top of my head about this agreement, but I do know that when I have worked on that agreement for a number of municipalities, there have been a bunch of red lines that we've made and suggested to them, and I'm happy to talk to you offline for a few minutes about what some of those are when I have the document in front of me. So sorry I can't be more specific, but we may be avoiding pole clutter, but my mind is a little cluttered right now, so that's about the best I'm going to be able to do for you here. So,
any other questions?
Yeah, I'm not seeing any other questions.
Okay. A couple of things we want to mention. So CML and CIRSA are going to be partnering to do some effective governance forums for elected officials around the state. Sam Mamet is going to travel with Tammy Tenoy from CIRSA, talking about some key leadership challenges that municipal elected officials face. So infrastructure finance, economic development, citizen engagement, council staff roles and responsibilities, council relations with each other. They're going to be held in Fort Morgan, Lyman, Glenwood Springs, and La Junta. So if you have any council members or trustees that you think would benefit from that, please encourage them to come. They're from 5:30 to 7 p.m., multiple days in April and May 4th in La Junta. The calendar, the schedule is cml.org under training events. They're all listed, and the RSVPs are there. They are free of charge for elected officials.
I want to also remind everyone that we have another municipal attorneys webinar coming up. I believe it's in April. I'm not pulling up the date exactly at the moment for legal issues around the administration of sales taxes, and on April 27th, and we hope that you'll look into that. That'll be included in our next municipal attorneys electronic newsletter that we'll be sending out, I believe, on Monday. So I hope that you'll sign up for that. We have some excellent presenters. This is a very important topic, and I want to thank, oh yes, before I wrap it up, let me turn it back to Ken.
Yeah, thanks, Sam. I realized I skipped over one part of one question. Jeff Friedland from Longmont asked about the question about the what are the boundaries of the police powers that 1193 preserves. And one of the examples he gave that I neglected to mention was co-location requirements. I think you can clearly require co-location when it is technically feasible. One of the things I've learned, and I'm certainly not a technical expert on this stuff, but I've learned a little bit about it, is that at the lower heights, there's really not a lot of room to co-locate, and the ability to co-locate when it's there is based upon the different frequencies that these companies use. If they're far enough apart in the parts of the spectrum that they use, they can do so without interference, but if they're close, and a lot of them are close, then you need like a 10 or a 15-foot separation between the antennas. So if you've got a 30-foot pole in the rights-of-way, you can't put somebody at 18 feet and have it still work. So you can require co-location when it's technically feasible, and if that's more important to a community than new poles, one of the things you can consider is allowing, you know, if the height limitation is 30 feet in that district, you can make an exception, say except for poles upon which small cell facilities are co-located, in which case they can go up to 40 feet or something like that, and then make it a little bit easier to do co-location. So sorry for not catching that earlier, and I'm glad I caught it before we finished. Back to you, Sam.
Okay, thanks, Ken. Let me just mention a couple other things here as we start to wind down, pardon me, and wrap it up. So I mentioned that we'll be putting out another municipal attorney's electronic newsletter out on listserv on early part of next week, Monday, that'll highlight a number of things that we're currently in the middle of. Let me just mention 2 or 3 of those. The league did file a letter with the Independent Ethics Commission in the last couple of days, objecting to their current position statement asserting their jurisdiction over home rule municipalities. Conference call was facilitated several days ago by Mike Hyman, the Aurora City Attorney, to consider other legal actions in that regard. And I'm expecting to see some of that continue to evolve over the weeks ahead. And if you have any questions on that, feel free to call me. The open records area of municipal law is pretty fertile at the moment, and Diane Criswell has been very involved with the legislation down at the Capitol dealing with open records. It's taken many twists and turns. She'll have a summary of that in the next newsletter, but certainly if you have some questions on that, do contact Diane. She's been working with a small working group of city attorneys to help her on that. It's been rather tricky, and it's a complicated issue. Our amicus work continues to be pretty robust. Just had oral arguments in a major governmental immunity case involving Colorado Springs, a so-called smoke brush case before the Supreme Court the other day. We're an amicus in that. We're waiting oral arguments in the state Supreme Court on another important case in which we're an amicus. That's involving the city of Aspen and their bag fee. And this turns on some Tabor questions, as well as the question of a tax versus a fee. And so finally, I want to mention our June conference. We have a terrific lineup of panels for the attorneys portion of the June conference. And the lunch speaker will feature Susan Daggett, who runs the Rocky Mountain Land Use Institute at the University of Denver, to review various current land use legal trends in Colorado and across the West. So I hope that we see you in June. I want to thank Ken Fellman. Telecommunications is an extremely important issue. He covered the gamut of issues today, and certainly he's always available for talking to you. His email address is on the PowerPoint, and I just want to simply thank Ken for his leadership, his help to the league. Spent a lot of time with Kevin Bomber on House Bill 1193. I want to also acknowledge Kevin's work on this at the Capitol, and I just hope that you've enjoyed the webinar today, and we'll continue to do these throughout the year. And as I say, the next one will be in April on various and sundry matters affecting sales tax appeals and other items related to the sales tax and municipal interests. So I want to thank you very much.
Okay, and we had said keep asking questions, and we got one last one that has come in, and maybe if somebody gets another one, and it won't be the last one. From Boulder, can you recommend any resources or consultants to inform our city about current technology advances? For example, knowing that base station equipment can be placed underground can inform our code changes and requirements. And so this is a question from Boulder, and let me say this. I would prefer not to give a bunch of promos for a variety of consultants for 2 reasons. One, well, the most important one is I'm going to leave somebody out. And so I'm happy to have you contact me offline, and I'll try to take the time to be more comprehensive. I will say this. One of them, the city of Boulder is already working with on your broadband stuff. So I'll leave it at that, and we'll make that offer to anyone who's on this call. If you want to talk more about, who's out there that can help us work on these issues, please just get in touch with me offline.
Great. Well, thank you, Ken. Appreciate everybody participating, and have a wonderful afternoon.